Sorry to be a little late, but I see it's enabled you to hand up lots of good stuff.
We come bearing gifts.
Yes.
Only in response to, I think, requests from the bench.
No, that's absolutely fine. Well, yeah, so I'm not sure I actually asked for, but it's good to have the Employers' Liability Act. That's beyond the call of duty, but thank you.
So Lord, that, which I think was the second document in the file, just shows that Section 1.1 that the requirement for insurance is in relation to bodily injury or disease.
Yes, thank you. That's interesting. I didn't know that, but that makes sense.
Also, I'm going to put that at the back of A5. But, that might be a convenient place to put it. That would be policies and legal materials.
But you needn't talk us to the others unless there's particular points you want to make. I can see what they are. Can you remember where the unreported Isle of Man case is?
The RBS case?
Yes.
Yes, it's also in A5 at tab 73.
Thank you.
And I hope that the report version I've just handed up has the same sideline as in the original. That's thanks to Ms. Fubista.
Extremely efficient, if it is the case. Thank you, Ms. Fubista. And yes, I'll put the statute back. And I should just tell you that I've been doing a little homework of my own. I did get out of the RCJ library Professor Courtney's book on the contractual indemnity. I haven't found in it any that casts a whole new light on the case, but I think it's a lot of good work, actually.
Yeah.
Showed what it does show, and I think this isn't a problem for either of you, but indemnities, things called indemnities, obligations in the general family of indemnities, arise in all sorts of circumstances and have all sorts of characteristics. You've got to decide what the content of the obligation is in the particular case.
Absolutely, Lord.
There's only one which appears, that I noticed, which appears to arguably give an entitlement to some sort of unliquidated damages. It's a very particular kind of case. Myself, I think it's necessary to look at it. In case anybody wants to, it's called Scott Lithgow, but it's miles from this case.
Yes.
But I'm just sharing with you in case you think I've got any unfair advantage from having looked at it. Right.
I'm very grateful, Lord. I didn't find it particularly illuminating on the issue that's facing this court.
No.
Lord, can I just say a word about the colour version of the APOC? Which
Yes.
Not entirely straightforward, so perhaps I can just explain. There is a code right at the beginning that explains the colour.
Yep.
And I won't read it out, the court can see what it says. The third entry says amendments in violence are those in respect to which the claimant requires permission or consent, i.e. entirely new amendments. Then blue, amendments in blue are those consequential on the judgment following the hearing on the 1st, 2nd October. That was the amendment application. But to illustrate what that means by reference to the flags paragraph, one goes to internal page 24. So this is before the renumbering which then took place. So it's now our 55.2, i.e. 54.1a is now 55.2 in the APOC. The first three lines of 54.1a are violet, just in case that wasn't apparent, because it's slightly obscure, I think.
It's violet and yellow. Yep.
Yes. And similarly, the first 2.5 lines of the first subparagraph.
Yep.
You then see a blue 3.5 lines.
Yep.
Those are effectively violet and blue in the sense that they were new, so they required amendment. And they relate to what I explained in headline terms yesterday about the deputy judge's ruling. So when the matter first came before the deputy judge, we didn't have the blue wording in this paragraph. We just had the violet in the draft amended particular.
But what the difference in the blue and the violet is they are both amendments.
Yes.
But One is thought to have been approved in principle, though not formulated. Is that right? By the amendment judgment. And the other is completely new. I can't quite understand the distinction between the blue and the violet.
Can I just then try and explain it in this way? Just the violet in this paragraph was in the original draft APOC before the judge at the amendment hearing, to which we said permission shouldn't be allowed because it doesn't give adequate particulars. Who was told at the respondent? How were they told? When were they told? And at the amendment hearing, the judge said, I agree, I would only give permission to amend, provided those particulars are given. The particulars that were then given is what we have in blue.
Yeah.
And we said, well, it still doesn't answer those questions. Who was told when and how were they told?
Yeah.
To which the judge said, as to all of this now, the violet and blue, well, I'll grant permission, but subject to this caveat, that it's clear that this is not an allegation of actual knowledge. Yeah. And if such an allegation were to be made, it would have to be by way of application to amend.
And in your certain argument, we'll find the cross-references for that.
Indeed.
Yeah. Thank you, that's very helpful.
And we'll also a hard copy of the transcripts of the last 2 days.
Yes. Well, right, well, we better let you get on, but that's been very useful.
Thank you.
A lot of work must have gone into doing that, but not overnight. That has always existed.
Yes.
Yeah. Thank you.
So, my Lord, I was yesterday dealing with ground 4. I had referred to the judge's approach to the indemnity in law. I had also been addressing why we submit the judge was right not to extend the indemnity in law beyond payments made or liable to be made, to include lost earnings. And I had shown the court 2 reasons which the judge gives in paras 3, 3, 4 for not extending the indemnity in law. The first reason, that it would sidestep the need for an incremental approach, and secondly, that it would cut across many statutes and legislative policy. So I dealt with that yesterday, just to refresh the court's memory, I hope, of that. There are 2 other reasons that the judge gave for not extending the implied indemnity in law, which are in para 336 of the judgment. The first is the huge burden it would impose on employers, and we see that halfway down 336, the sentence beginning, an imposition of strict liability through the implied indemnity would impose a huge burden, and so on. And it's in the following sentence that the judge refers to the insurance question, which my Lord raised yesterday, where the judge also had that in mind. So that's all part, we say, of the third reason for not extending the indemnity in law. The huge burden have to be seen how that would affect insurance. And then the fourth reason, which follows, is the without precedent reason. The judge reiterates here the point about, from the researchers of counsel, no precedent for the indemnity covering loss of earnings. Lords, can I then turn to the criticisms made of the judge's approach? And what I've proposed to do, if it's convenient, is do this by reference to my learned friend's skeleton argument, because I'm conscious the court will take that away. And considering some of these points he dealt with, my learned friend dealt with orally. But the criticisms on this topic are found in paragraphs 51 to 55 of my learned friend's skeleton, which is in Core Bundle tab 4 at page 47. And for the court's note, we deal with this in our skeleton in paragraphs 88 to 98. And what we see first at para 51 is 5 subparagraphs which seem to advance different arguments as to why the judge was wrong. Some of them I can hopefully deal with very briefly because we've already seen a number of the authorities. So 51.1, the first argument, it said, well, there's clear authority that shows the scope is wider than payments made or to be made. 3 authorities are referred to. In our submission, they don't support that proposition. We've seen the cases. They contain statements of the indemnity, but one, as I think the bench has observed, has to be read in the context of the facts of the case. And I think they'll all be familiar now to the court. So Famatina was the case where the employee recovered the costs of defending the defamation proceedings. So that was a payment made. In the Birmingham case, there was no indemnity. That was the sale of the land, and there was some discussion about what the indemnity principle might cover. But it wasn't relevant to the facts of that case, and nothing was said about the scope. And thirdly, First Names Jersey. Again, that's, I'm not sure if the court has seen that. Well, it's in A453, and it really doesn't take the matter anywhere.
We won't go to it unless you want us to.
Well, can I just say this? It was a case involving a trust management services company in Jersey that provided its employees to act as directors.
Yes, I think in fact I looked at it in my pre-reading, yeah. And
the directors were then sued allegedly for alleged breach of fiduciary duty, and the company that employed them said, well, we must indemnify them for any such liability, and the indemnity was challenged by an interested third party. It was governed by Jersey law, and Mr. Justice Robin Knowles simply said there is an indemnity available in these circumstances to the employees if as part of their job they're sent to be directors of companies, and they're then sued in that capacity. But that's as far as it went.
And the nature of the quotes loss indemnified against was the amount of the liability to the third party, which either had been or by definition would be quantified.
Yes, it hadn't, I think, been established yet. It was but it was the potential liability.
Yes.
For breach of fiduciary duty to the third party. So again, that falls, we say, within the traditional scope of the indemnity. So the authorities don't support the proposition. Now, the judge, of course, considered not only authorities, as the court has seen, but commentaries which discuss the indemnity. And I think the court has looked at some of those commentaries. What we say about those commentaries, Halsbury and Chitty, is that they use a variety of formulations. And in fact, there's a broad thrust which uses the language of liabilities and expenses. And so if one is saying, well, what do the commentaries say about it? They don't all speak with one voice using the language of losses. They do sometimes use the language of losses, and they refer to authorities in support of that proposition, which are the authorities that we've seen, so they don't take the matter anywhere. Yeah. And I don't know if it's helpful at this stage just to highlight the particular authorities that we draw the court's attention to, the commentaries. First, Bousted is at A575. And it's Article 62 of Bousted. And one notes the heading, page 2090 of the bundle. The heading of Article 62 is Reimbursement of Expenses and Indemnity from Liabilities. except, of course, that losses is then referred to in the second line underneath that, but it's interesting that that is the heading. And in fact, if one turns over the page to the paragraph 7059 with the heading contract at the top, fourth line down, there's no difficulty in such cases holding the principal is liable to reimburse and indemnify the agent for all payments made and liabilities incurred. So again, it's the language of payments made and liabilities incurred. Chitty on agency follows in the next tab at 76. There are a few extracts from Chitty, first on the test for implied terms, but if one goes within this tab to page 2101, this is the agency chapter of Chitty, we see at the top indemnity of agent, unless otherwise agreed, the principal is under a common law duty to reimburse and indemnify the agent against all expenses and liabilities. So again, that language is there used. No reference to losses. Chitty on employment appears behind tab 77 at para 42117, duty to indemnify the employee. And we see in the first sentence that it refers to against all expenses, losses, and liabilities. So the word losses is included there, but if one looks at the end of the sentence, footnote 871 is said to support that proposition. And 871 refers to Adamson and Jarvis and Pantila, which we know are cases of payments made or liable to be made.
This is, I think, Professor Freedman.
It's Mark Freedman.
Mark Freedman.
Jeremiah
And
Adams.
yeah.
And then at tab 81 is Halsbury's laws on agency. And we see page 2127 of the bundle at the top of the page, para 112 of Halsbury. The relation of principal and agent raises by implication a contract on the part of the principal to reimburse the agent in respect of all expenses and indemnify him against all liabilities. Now, I should draw to the court's attention the next paragraph, 113, on extent of the indemnity, which says the right covers not merely losses actually sustained by the agent, but also in accordance with the principles of equity, the full amount of the liabilities incurred, even though they may never in fact be enforced. And footnote 1 refers to Lacey and Hill, which we discussed briefly yesterday. That was the case I mentioned of stockbrokers, which established that the indemnity covers a liability even when the payment has not yet been made.
Yes, I mean, that can be a bit tricky. I see it says that in the footnote, a possibility of a future claim is not a possibility of a future claim is not. But if there is established liability but it hasn't been paid, you can get your money, and then, interesting question, I suspect you are, whether you're under any obligation then to use it to discharge the liability, who knows? That's somebody else's problem.
Yes. So all this does in referring in 113 to losses and liabilities distinguishes in our submission between losses, i.e. payments that you have made, and liabilities, payments that you are liable to make. It doesn't suggest a wider type of loss is recoverable.
Is this because at common law, as distinct from equity, you had to have made the payment, otherwise you couldn't sue under the indemnity?
Well, we suggest that that probably is the explanation, and that's why we refer to the firma trade case, where I think it was Lord Hoffman.
Or Brandon,
Brandon, sorry.
Yeah, I read that.
Who explained, I think, that historic distinction. So in common law, the party to be indemnified had to have made the payment, and then he sued for damages for breach.
Exactly.
Hence, it was a loss.
Exactly.
And but equity said, well, we'll intervene if you don't have to pay. If it's a liability to pay, then we'll come to your aid.
Because
Hence,
of
the
the
loss
principle.
liability.
Yeah. Is that because of the general principle that equity deems to be done that which ought to be
I think that's probably right, my lord. And then after 1875,
Fusion.
fusion, and hence losses and liabilities is the language. So, well, that's 51.1 of my learned friend Skousen. We say there's nothing there that assists him. 51.2, he says there's clear authority that the scope of the indemnity covers losses other than payments to discharge liabilities in other contexts. And this is the Sagona. And one notes that right at the outset, the way my learned friend puts it in that sentence, this is another context. This is not the employment context, it's not the agency context, it's another context. And what we say by way of general comment here is that the Sagona is the only authority that all of the researchers of the appellant's very experienced legal team have managed to discover in any context in which there's some suggestion that lost earnings might be recoverable under the indemnity. And we say that alone suggests that the Sagona is outside that line of authorities in employment and agency cases, which don't extend in that way. So that's really the starting point. The Sagona is not only an outlier, but is out with the consistent line of employment and agency authorities. I'm going to deal also in a moment with the INI costs, which Lord Justice Singh particularly raised with me yesterday, which Mr. Toomey mentioned in this connection. But we say on close analysis, the INI cost is not a case where there's recovery of lost earnings. So I'll come back to that in a moment, but that's why we say the Sagona stands on its own. And we say there are three relevant features of the Sagona that need to be borne in mind when considering it. The first and obvious one is it's a charter party case. And when the court is considering whether to imply a term as a matter of law, as we know the test is whether it's a necessary incident of the contracts of the particular category with which the court is dealing. And therefore, it doesn't follow that what might be a necessary incident of a charter party contract assists at all in deciding what is a necessary incident of an employment contract. And there are many weird and wonderful features of charter parties with which the court may be more familiar than I am, but one just observes there are multi-parties in these type of shipping cases. It's not a bilateral contract. One has ship owners, charterers, ship's agents, shippers, recipients of cargo, ship's agents on the wharves. Many, many parties are involved. One has two contracts that are engaged. There's the charter party contract and the bill of lading, two contracts. There is, of course, critically, the vessel, which is at the heart of the charter party and disputes about charter parties, where the master of the vessel is employed by the ship owner, but is subject to the direction of the charterer. There are particular remedies, such as arrests of the vessel in the event of disputes. So a very different context than the employment context. And we submit that it's inappropriate to simply read across from the charter party context into the employment context. And of course, what the court is asking in considering whether to imply an indemnity at law into the employment contract is not only whether it's a necessary incident, but what would be the repercussions in the employment context of implying the indemnity. So that's our first point. You can't read across from that context to this. The second point, my lords, about the Sagona is the loss of earnings was conceded to be recoverable. It went by way of concession. And one can see that if one turns up the authority, which is in A1, tab 21. using the law report pagination, page 196. At the bottom of the first column, 5 lines up, we see that the shippers sued Benyatov. So the shippers who originally owned the cargo were selling it. They sued Benyatov, to whom the cargo had been unloaded, and various other parties concerned in the purchase of the cargo. They recovered judgment. While an appeal was pending, a compromise agreement was made under which one of the other parties paid the shippers. So any liability of the owners to the shippers for misdelivery of the gas oil was disappeared. Second mortgage released. Owners had still suffered losses. These, it has been agreed, are as follows, and then there are different heads of loss, including loss of earnings while the vessel was under arrest. We don't have any more details of those losses or how they're calculated, but the quantum seems to have been agreed. But then if one goes on in the report to 204, at the bottom of the first column, the heading, the right to indemnity, this was the alternative ground for the owner's claim. Mr. Dean for the charterers, so the charterers there being sued under the indemnity, accepted that if the charterers had expressly given...
Sorry, which page are we on now?
204, my lord, of the internal report.
Yeah, thank you.
Bottom of the first column.
Yeah, got it.
Mr. Dean for the charterers accepted if the charterers had expressly given orders for the cargo to be delivered to Benyatov without production of the bill of lading, they would have been liable to indemnify the owners at any rate unless the master had reason to believe that Benyatov were not entitled to receive the cargo. That concession was based not on the express indemnity in clause 30, but on the implied promise of indemnity which has been held to exist alongside it. So the charterers conceded that if they had given this direction to the ship owners to unload the cargo, then they would have been liable, and liable to pay the sums that were claimed. So there was no argument, it seems, in the case as to whether or not the sums claimed were beyond the scope of the indemnity or not. It went by way of concession. So one doesn't really derive any assistance from the case to the effect that here it shows that the scope of the indemnity is held to cover loss of earning, because that was not a live issue in the case.
When it says the implied promise which has been held to exist alongside it, is that then, as it were, particularised by the reference to Strathlawn? Is that what he's referring to?
Well, he goes on to discuss Strathlawn, which I was going to come on to. One sees here that there was an express indemnity, which was in clause 30.
Yes.
So it's express, but also implied, because the terms of the express indemnity didn't cover the facts of the case.
Right. But all I wanted to know is when he says which has been held to exist alongside it, that's obviously a reference to other authority. He doesn't say what that other authority is, perhaps because all shipping lawyers know it, or perhaps because it's actually referred to in what follows. But you'll tell me.
Well, Lord, our view is that it is a reference to what is understood by charter parties and charter party lawyers. And we maybe get some assistance on this point from the Aini costs, because you remember that in the Aini costs there was an express indemnity. But Lord Sumption in that case says that the express indemnity there, which was against all consequences and liabilities, was the same as the implied indemnity in charter parties if there was no express indemnity. So there seems to be this common feature of charter parties, that there will generally be an express indemnity, and if not, an implied indemnity in the same sort of terms as the express indemnity. Now, that, of course, is very different from employment contracts, because it's not a common feature of employment contracts that there is an express indemnity in any terms. all that we have is...
But the broad thinking behind it is, if I give you the use of my vessel for so many months, and I, as owner, incur liabilities from the way you have used it, you'll have to pay me back.
Yeah. You can tell me...
And that may well be... Well, that's the more obvious indemnity bit of it, but it wouldn't be surprising if there was an obligation. Well, I don't know. I don't quite understand what this loss of earnings was,
we don't
because you would have thought that the charterer will pay the owner anyway as the hire. So what are the additional earnings?
The report doesn't shed any light on it. Yeah. So that's why it's also very limited assistance. What we know is that the vessel was arrested by the shippers whose cargo had been on board but delivered to apparently the wrong party who hadn't yet paid. And it was the shippers arrested the vessel, and the sum claimed by the ship owners from the charterers was tied up with that liability of the ship owners to the shippers, i.e. the cargo owners. So it's connected with the injury to the rights of the third party in that case. And my Lord Justice Singh, I think, had referred to the quote from Dugdale and Lovering on the following page, which relies on that. So it's very difficult to really get to the bottom of this case because of the limited facts as to the loss of earnings. But we say that concession is an important feature of it. Yeah. Now, there's a third point I was going to make, and I hope I can deal with it quite briefly, which is the case also seems to proceed on the view of Mr. Justice Staunton that, in fact, the charters were in breach of contract by giving the ship owners a direction to unload the cargo without production of the bill of lading. And it's that which emerges from the quote from Strathlawn, because we can see from Strathlawn, which is Mr. Justice Roche's judgment, about halfway down the right-hand column in the quote, after the reference to Dugdale and Lovering, and following the word consequences 3 lines below Dugdale, Mr. Justice Roche in Strathlawn said, or on the other hand, as is in my view the case, after the bill of lading has been issued under which the ship owner became liable, it was not lawful under the contract to require him, without his consent, to deliver to anybody else, or to instruct or direct the captain to deliver to anybody else. If that's the true view, then so as to make delivery on the part of Jardine Matheson, or instruct the master to give delivery, was a breach of contract. Now, that, as it were, is the starting point for breach of contract, because we then need to turn over the page to 205.
Just pausing there, I mean, if we think it necessary to go into this degree of detail, which who knows, it may be that the origin of the implied promise of indemnity is Kruger and Moll-Trevan, which is referred to there, which refers to an indemnity by way of damages.
Yes.
Might be worth someone just seeing whether there's anything relevant in that, but giving us a copy if only so we can cross it off our list.
Thank you, we will. I think I looked at it earlier on and must have decided it didn't shed a lot of light, but we'll look at it again. We'll consider providing a copy if that would be helpful. And so one then goes over the page at 205. Now, the quote from Mr. Justice Roche in Strathlawn ends, again, with the reference to Kruger. So it's at the end of the sublining. It wasn't entirely clear to me initially where the quote ends, but that's where it ends. And so Mr. Justice Staunton then says, I cannot attempt to improve on the reasoning in that passage, save on one small point which will be mentioned later. I would add that, in agreement with Mr. Justice Roche, I prefer the view that an order by the charterer to deliver to the wrong party is not a lawful order, under the Charter Party, and is not an order which a shipowner is bound to obey. So Mr. Justice Staunton seemed to agree with Mr. Justice Roche that that would be a breach of contract for the charterer to order the shipowner to deliver cargo to somebody who's not entitled to it. And that is, of course, what happened in the Sagona, because the charterer told the shipowner to deliver to Mabanaft, who was then became the recipient of the cargo when it wasn't entitled to it. And again, just to try and complete this point, on the second column on page 205, the second paragraph halfway down, Mr. Justice Staunton says, seeing that Mabanaft were not in fact entitled to receive the cargo, the order was one which, as I hold in agreement with Mr. Justice Roche, the owners through their master were not bound to obey. So it seems that Mr. Justice Staunton was of the view that in the Sagona, the order by the charterers to the ship owners to discharge the cargo to Mabanaft was a breach of the Charter Party, and therefore the recovery here, including for the loss of earnings, was a recovery for breach of contract, damages for breach of the Charter Party.
So if there were, just to be clear, I've understood this submission correctly, I think what you're saying is that if there were to be a valid analogy with the present case, there would have to be a breach by the employer of its obligations to the employee, not an assertion that loss has been caused by the actions of a third party. Is that right?
Well, we would say if it were to be an analogy, there would have to be a breach of contract. So the recovery by Mr. Benyatov would have to be for damages for breach of contract, as opposed to a recovery under the implied indemnity.
Yeah.
So, Lord, those are the three.
There were a couple. Before we leave the Sagona, I understand your point that it's difficult to see how an analogy can really be drawn with the employment context. But I just wanted to tease that out a bit, if I may. One point, as I understand it, is that here the loss of earnings claimed in the Sagona had already been incurred. Is that right? They're talking about past losses. It's not, for example, like in the present case, we have a future loss of a career that's being claimed. There's nothing analogous to that, is there?
No, there isn't. I respectfully agree.
Yeah, and the second thing is that insofar as one can understand what the nature of the loss of earnings would have been, and as you say, no light is shed on that in the report, but insofar as one can understand what it might be, I suppose in principle it could be that if your vessel has been arrested, then you've lost out on the opportunity to use it to earn money in some other way. Even if that holds true in that context, I'm speaking for myself, I don't see how that analogy can hold with the employee's position. Let's suppose an employee is arrested and says, well, I wasn't able to earn money in the team. Well, here there's no issue. The employer has always said, we'll pay you under the contract of employment. So you haven't lost any earnings in that sense while you were under arrest. Am I missing something?
No, my lord, I respectfully agree, which is why part I drew attention to the centrality of the vessel in the Charter Party context. There was the arrest of the vessel, and the ship owners presumably were unable to use it for other purposes during the period of the arrest. But that is not in any way analogous to the situation that we're facing. And my lord, that's the Sagona. Yesterday, in oral submissions, Mr. Toomey added the Enikos, that's the right way of pronouncing it, and said, here's a second example of recovery for loss of earnings. The court could turn that up. It's A3 at tab 44. Once again, it's our friend, the Charter Party context. And we say, this is of no assistance, and I'm going to give some reasons, but perhaps centrally on close analysis, this is not a loss of earnings case. So that's the point I'm going to come to. But my first point on the ANI costs is the same as my first point on the Sagona, which is this is all a charter party context, and you can't read across from charter parties to employment. That's the general form. Secondly, the ANI costs concerned an express indemnity, so it's not on its facts about the scope of any implied indemnity. We see the express indemnity at paragraph 8 of Lord Sumption's judgment, page 173, the internal numbering of the report. And we see it's an indemnity against all consequences or liabilities. And interestingly, at para 9, Lord Sumption says clause 13 is the employment and indemnity clause, which is found in most modern forms of time charter. This seems to be pretty common, no doubt agreed between those parties who operate in that business. And as he goes on to say, and I think this reflects what my Lord Justice Underhill was suggesting a moment ago, the indemnity reflects the breadth of the powers conferred on the charterers as to the employment of the vessel, and refers to Mr. Justice Devlin's comment in the 1949 case. So it appears that parties entering into these standard form contracts had no doubt considered the appropriateness of the language of the indemnity and agreed this, which is pretty standard. And as Lord Sumption says at para 10, this is very wide. And he says, like the corresponding implied term, so it seems that perhaps in charter parties, the corresponding implied term, where there's not an express indemnity, is similarly very wide and covers all consequences. So the case turns on the wording of the express indemnity, so it doesn't assist us for that reason. But thirdly, as I say, and this is the point I've trailed, the claim wasn't for loss of earnings, but for payment for service of the vessel. Now, one just remembers the facts here very briefly, that the charterers had caused the vessel to be loaded with cargo, at which point the charterers failed to make their hire payment. The ship owners exercised a contractual right to withdraw the vessel from the charter party for non-payment of the hire, even though that wasn't a repudiation. So they took the vessel out of the charter party, no doubt, because at that point they could then use it again at better market rates. But it still had the cargo on board, and the cargo had to be loaded, had to be unloaded. And in those circumstances, it seems to be accepted that the ship owners owed a duty of care to the charterers to take care of the cargo. So the vessel remained in port whilst the cargo was unloaded. And that took the 2.64 days, which is referred to in the headnote and elsewhere, as the period of the loss. If one then reads the first sentence of paragraph 4 of Lord Sumption's judgment at page 172, we can see he says the issue before us is whether the owners are entitled to be paid for the service of the vessel during the 2.64 days. So the vessel was out of contract, but it was still, as it were, being used by the charterers or at their disposal because the cargo, their cargo, was being unloaded. The question was, well, who was going to pay for the service that this vessel was providing over these 2.64 days whilst unloading the charterer's cargo? And the answer was, well, the charterers are to pay for it. How do we calculate what they should pay? Well, it's the market rate for the vessel for 2.64 days. And we see that explained in paragraph 17 of Lord Sumption's judgment, page 176, where there's first subparagraph, he says, in my judgment, the whole of the 2.64 days during which the vessel was detained resulted from the cargo being on board on the charterer's orders at the time of withdrawal. Then at subpara 2, it's not suggested there's any difference in the circumstances of this case between, 1, the measure of the owner's loss in having to await discharge and then discharge in their own time, and 2, this is, we emphasise, reasonable remuneration for involuntarily making their ship available during that period. On the face of it, the opportunity cost to the owners of the detention of their ship is the market rate of hire at the time. In the absence of any subsisting contractual obligation to make her available at any other rate, the owner's loss is the market rate of hire for 2.64 days. So it was a charge for use by the charterers of the vessel in unloading the cargo, calculated in that way. It was not a claim or recovery for lost earnings.
Well, I'm not sure about that. It was, as analysed here, effectively a claim for loss of use of the vessel, which is not in principle a liquidated sum, but can easily be, well, not easily, there may have been issues about what the market rate was, but can in principle be calculated in the way that Lord Sumption explains. So in that respect, it's more like a damages claim. To me, it does seem to be the case that whether this may be a clearer example of it than the Sagona, because it's rather unclear what's happening in the Sagona. There may be cases where something which is called an indemnity is an obligation to make good a loss, which will have to be assessed by somebody. You can't just say, here is the money I paid out, or here is the money I'm liable to pay out. It is, in that sense, analogous to a payment by way of unliquidated damages, obligation to compensate. I don't think that's fatal to your case, because you can say, well, that may be what indemnity means in this very specialised context. And for what it's worth, I think in something like that in the Scott Lithgow case as well, to which I drew your attention. But that doesn't follow that every indemnity or any indemnity, any quotes indemnity, can be of that character. You've got to look at the particular relationship.
Well, respectfully agree with that. One shouldn't get misled by labels. It's about substance. But and one can see how in the INI costs, given the terms of the indemnity, the express indemnity, it might well be said, well, this was a consequence of complying with the charterer's order to load the cargo and then have to unload it.
Sorry.
But I did want, if I may, just to come back on the point that this is really a loss of use case. It's not in the sense that, well, the vessel was just stuck there and nobody was doing anything with it. It was the vessel was being used to unload the charterer's cargo.
Yes, but from the owner's point of view, it's a loss of use. The owners don't have it at their disposal.
Well, that's right. And it might be these are two sides of the same coin, but the owners are saying, this is at you, this is at your disposal, charterers, at the moment. We're working our vessel for you because we're unloading your cargo, which is partly why the charterers also had to pay for bunkers used for the petroleum, the oil, for running the vessel. That was a cost recovered here because it was at the charterer's disposal and use. In the same way, our submission, that it was the vessel was being used by the charterers for the unloading of their cargo. Now, you could say, well, that meant the owners couldn't use it elsewhere. But I think, with respect, it's different because it was a direct use for the benefit of the charterers.
But think about it. You haven't totally persuaded me, but I'm not sure that even if you haven't, that you have your other points.
Yes, there are the other points too. Well, that responds to 51.2 of Moe and Friends skeleton, the other contexts. 51.3 says that there are examples of the awards of loss which go wider than payments made in discharge of liabilities. Now, two cases are there referred to. One is Frixioni and Tagliaferro, our great Genoa dispute. And the point being made there is, well, it said, look, here's interest which is being recovered, and the court has seen that case, and we say, well, the interest there is running on the liability which the agent had to discharge to the third party, Passano. So the interest follows from the liability and is parasitic on it. It isn't a different category of loss. The second case is Burrows and Rhodes, which we just say is of no relevance at all. That was a case of damages for fraudulent misrepresentation. So that doesn't assist. Para 51.4, it said the distinction drawn by the judge is an unprincipled one. And I think I hope I've dealt with this at least. I've addressed it. This is well, what if it's a fine? But we say, well, that would be a principled distinction, because if a fine is payable, it's a sum that's paid or liable to be paid by the employee. So if the employer pays it, it falls within the traditional scope of the indemnity. That doesn't mean that the employer would be liable for loss of earnings following conviction, whether there was a fine or a sentence of imprisonment.
Suppose the employee is arrested because what he's done is on the company's business. Suppose we don't then get proceedings or a conviction because he's released, but he's in detention for a period of time and suffers great distress because of the prison conditions or some other reason. What's your submission on? Obviously, loss of earnings probably won't be an issue because they'll be paying under the contract of employment anyway. Yeah. But what about the other damage he has suffered in that detention? Do you say that he's not entitled to anything for that?
Not under the implied indemnity, Lord. Whether he might have another claim, for example, in negligence, but on a fault basis, if the employer is at fault. But otherwise, he hasn't suffered a loss in the sense of a liability to make a payment. And so there is nothing to recover under the indemnity. Of course, with all cases where one has to draw a line, one draws it on a principled basis, and some cases fall one side of the line, some fall the other, but that's as a result of drawing a line on a principled basis. It doesn't mean one doesn't draw the line or doesn't move the line just to meet a particular case. And then 51.5, it said, well, the judge recognised that it's at least possible that an indemnity in fact could extend to cover loss of earnings. Well, the judge is simply dealing with indemnity in fact there, and the judge makes the observation, it's paragraph 365. In fact, what he said was it's not necessary to consider whether the scope of the implied indemnity of fact could extend to loss of earnings in an appropriate case. So he's saying here it's not necessary for me to consider what might happen in an appropriate case. In fact, that would be for that case. That's dealing with indemnity in fact, not in law, and we know what the judge's findings on the indemnity in fact are. So that point doesn't go anywhere. So those are the paragraph 51 criticisms. The paragraph 52 criticisms are all concern Whitlam, and I know I've taken the court through Whitlam, but can I just run through these criticisms for completeness? 52.1 says the judge wasn't bound by Whitlam. Well, it's a strange point. I don't know whether it suggested the judge considered himself bound by Whitlam. We say clearly he didn't, and it was never suggested that he was bound by Whitlam. 52.2, it said...
And the point about a different result might have been reached in English court was on a different aspect.
Yes, it was. Well, that was on the aspect of, well, the employee recovered in Famatina, costs of defamation proceedings, how has Mr. Whitlam not recovered the costs of defamation proceedings? To which I think my Lord Justice Bean provided the answer, which is right in our respectful submission, that the difference between the two cases was in Famatina, the employee was being sued for what he'd done in his job and incurred those costs. In Whitlam, it was Mr. Whitlam commencing proceedings himself. That was the difference. But it was on a different point, my Lord. Then at 52.2, it said, in fact, as both parties accepted the indemnity applied in the circumstances of Mr. Benyatov's claim, and so to the extent there's any cutting across the law of tort, it's already a fact. We're having some difficulty understanding what that point was. We accept that there was implied in Mr. Benyatov's contract an indemnity of the limited scope for which we contend, but that doesn't mean there's any cutting across the law of contract. An indemnity to recover for payments made or to be made is to ensure the employee isn't out of pocket as a result of doing his job. That doesn't cut across the law of tort, which is there to provide compensation for the wrongs done to an employee. So we don't see that there's anything in that point at all. Then at 52.3, the Lords will have read this. It seems to, it's a rather tenuous argument which we've had difficulty in following, but seems to proceed along these lines, that under the indemnity, the employee could recover for loss of earnings. Then there was a limitation imposed as a result of the doctrine of common employment, and it was that limitation of common employment which led to statutes like the Employers' Liability Act of 1880. And so it's wrong to say that extending the indemnity would cut across the statutes when the statutes were only in place to address the limitations of the indemnity. That's the best that we can do to understand the argument with respect. And we say, if that's the argument being put, it's historically inaccurate for the following reasons. Firstly, it was never the case that the employee could recover loss of earnings under the indemnity. Secondly, that had nothing to do with the doctrine of common employment. As the court will know, the doctrine of common employment was that introduced in the middle of the 19th century, where the employer was not to be vicariously liable for injury to one employee caused by the acts of another employee who was engaged in common employment. By the 1930s, when we had the case of Radcliffe and Ribble, which is referred to here in the footnote, most judges looked askance at the doctrine of common employment. But as was stated in that case, the Employers' Liability Act of 1880 recognised that the doctrine existed and introduced ameliorations for that doctrine. So that's all to do with the doctrine of common employment, which was abolished in 1948 anyway. So it isn't an answer to the cutting across statutes point at all. That concern about cutting across statutes described by Mr. Justice Freedman remains if the extended indemnity were to be recognised. And then at 50, let me see, where do we go? 52.4, it said, well, the New South Wales Court of Appeal in Whitlam didn't address the situation where there's a third-party interaction. Well, what we say about that is, firstly, Whitlam was a case where there was third-party interaction, because there was interaction between Mr. Whitlam and the broadcasters, who he said had defamed him. So where Campbell J.A. was discussing in paragraph 94 what the impact of recognising the wider indemnity would be, it was against the backdrop of a third-party interaction case. But secondly, we say if the extended indemnity is recognised but limited to third-party interaction cases, it would still have the wide-ranging ramifications that we have sought to describe, because many of those cases where we say it would have applied if the appellant is right and it exists, and would have changed the outcome of the cases, were third-party interaction cases. And I won't go through the exercise that I parked on yesterday describing some of those cases, but the court will remember Reed was a third-party interaction case. Crossley and Faithful was a third-party interaction case, the employee and the insurers. James Bowen was a third-party interaction case, the police officers and the suspect. Rehan, in fact, would be an example of such a case. Mr. Rehan ran into difficulty with the Dubai regulators, who he said were pressurizing him to cover up the unethical audit. If the extended indemnity applied, it would have given a simple answer to Mr. Rehan. It would have provided him with a remedy. He said, I've suffered loss of earnings as a result of the run-in I had in the course of my employment with the third-party regulator. Nobody thought, it seems, certainly didn't claim the indemnity in the Rehan case. So if it exists, it would apply in all these many cases involving a third-party interaction, would have produced a different result, but nobody thought of it. Why not? Because it doesn't exist. So, well, that's paragraph 52, and all that's left in this section, in my learned friend's skeleton, is paragraphs 53 to 55, which deal really with the 19.2 indemnity. My learned friend does say, well, this brings to the fore who's to bear the risk. But we say, well, that isn't the test for the implied indemnity in law, who bears the risk. The test is whether it's a necessary incident of a category of contract, i.e. the employment contracts. My learned friend sought to make some, we say, one-sided and self-serving points about, well, here's the bank getting all this benefit from Mr. Benyatov's employment and work and getting the fees. Of course, an employment contract is intended to be mutually beneficial to the parties. Of course, the employer hopes to benefit from the employee's work, but the employee in the position of somebody like Mr. Benyatov earns seven-figure bonuses, promotion, and status. There is some risk to be borne by both parties in those circumstances. And it can't really be said in our submission to be a necessary incident of the employment relationship that the respondent here, like any other employer, should bear all of the risk to the employee of the actions of the authorities of a fellow EU member state, particularly when those actions were not reasonably foreseeable. Paragraph 55 criticises the judge's approach to the 19.2 indemnity, but I've dealt with that briefly already, and the court has seen how the judge approached the 19.2 indemnity, that it's not a separate indemnity. What was being said in Lister simply delineated the circumstances in which the original indemnity, if you like, would be lost. And we say the judge was right to so analyse it. And I don't propose, unless the court wishes me to do so, to spend longer on the 19.2 indemnity. I would just invite the court to note that the formulation of the 19.2 indemnity, said to be based on Lord Tucker's wording in Lister, doesn't in fact reflect his wording. Lord Tucker in Lister at page 595 referred to liability, not losses. That might be a small point, but as a point of detail and accuracy, he didn't use the language of losses, but of liability. Well, for all of those reasons, we say that ground 4 should be dismissed. Can I then turn to ground 5, the indemnity in fact, and deal with it much more briefly, I hope, than ground 4. So the appellant says the judge erred in concluding that no indemnity in fact was to be implied in the case. We make two preliminary points before turning to the criticisms of the judge's approach. The first is this. The court is, of course, already aware that the facts and matters relied on in support of the indemnity in fact are the same as those relied on in support of the duties of care. See APOC para 25, the 23 subparagraphs. We looked at them yesterday. In considering the judge's approach to this matter in his judgment, and particularly the criticisms made by the appellant of the judge's approach, it's relevant in our submission to have regard to the fact that in his written closing submissions following trial to the judge, this matter, the indemnity in fact, was dealt with in only 2 paragraphs, consisting of a total of 9 lines, covering less than a single page of the 142 pages of the appellant's written closing submissions. And 2 points only were made there in those 2 paragraphs.
Are you going to take us to them? Have we got them in the bundle?
They're not in the bundle,
Okay,
my lord. I
that's
can
fine.
certainly provide them. But
No, don't particularly want them, but I just thought if we had them, we'd
just
use them. Yep.
the first point made was, it was said, well, the nature of the contractual relationship, one of employment, was relevant to whether the term should be implied. And second, the unusual facts of this case meant there was strong justification for the implied term in view of the matters referred to in APOC, para 25. Therefore, when the appellant criticises the judge, as is done in para 56.2 of Malone and Friends Skeleton, for not separately analysing or considering the facts found in relation to duty of care in connection with the indemnity in fact, has to be seen in the context of the respect of the scant detail with which the appellant dealt with that aspect of the claim in closing. In fact, as the judgment shows, the judge dealt with both of those matters, that it was a contract of employment and the APOC 25 facts and matters. So he addressed in his judgment, in this connection, the 2 matters specifically drawn to his attention in the appellant's closing submissions. The second preliminary matter on this point is to note the judge's references, in the plural, to the test for an implied indemnity in fact. The judge refers in 3 places in his judgment to the Marks and Spencer test. I'm not proposing to go to that authority unless it would assist, but for the court's note, the Marks and Spencer case is at A3 tab 50. The court will be very familiar with this, I'm sure. It's paragraphs 18 to 21 of Lord Newburger's judgment in that case that sets down the test. In submissions to the trial judge, both parties had referred to and quoted from that authority, and we had specifically identified the 4 limbs or requirements to the test. One, that the implied term must be fair and reasonable. Secondly, that it must be either necessary to give business efficacy or so obvious that it goes without saying. Thirdly, must be capable of clear expression. And fourthly, mustn't be inconsistent with any term of the contract. So the parties had made all of these submissions. And the judge refers to the test, firstly in paragraph 305 of the judgment, then in paragraph 338, where he referred to the narrow approach to implied terms in the case, M&S case, and also at 365, where he referred to the test as being very limited. So one can proceed on the basis the judge had the test well in mind when addressing the indemnity in fact claim. Now, as to the criticisms made by the judge, first at para 56.1 of Malone and Friends Skeleton, it said, well, the judge didn't take account of the fact that this was a risk that the appellant did not and would not have undertaken. It's not entirely clear to us what the this is referring to in 56.1. It wasn't part of the appellant's submissions or pleaded case that he relied on a particular risk that he was unwilling to take in support of the implied indemnity in fact. That's not a factor in the APOC 25 list of 23 facts and matters. In fact, the judge did consider all of those matters on which the appellant's pleaded case relied. In any event, what risk the appellant was or wasn't prepared to take doesn't form part of the test for the implication of terms in fact in Marks and Spencer. And then at 56.2 of my learned friend Skeleton, it said the judge didn't analyse or consider the facts that he'd found in relation to duty of care separately in connection with the different considerations relevant to implied indemnity in fact. But we say that's based on a misreading of the judge's approach. The judge did in fact analyse and consider facts separately, as one can see from that part of the judgment when he dealt with indemnity in fact, beginning at paragraph 359, because he summarises those facts and matters at 361. And one bears in mind that he's said in a number of places that these are summaries, that he's taken all of the facts and matters into account. And at 362, he again sets out his key findings on the critical factors. There would be no point in him setting them out and referring to them again if he was not separately considering them in the context of the indemnity in fact. That's the very thing that he's doing here. It would be pointless to set them out extensively again, as he has done previously. And having found, as the judge found, that the facts on which the indemnity in fact was based were not made out, it was inevitable that the indemnity in fact claim would fail. If the substratum didn't exist, the claim can't succeed. And plainly, the judge considered that the Marks and Spencer test wasn't satisfied in this case, as indeed, plainly it wasn't. Was this implied indemnity, in fact, necessary for business efficacy? No, plainly not. The contract doesn't lack practical or commercial coherence without the implied indemnity. Is it so obvious that it goes without saying? Trying not to fall into the schoolboy error, one asks the question, the officious bystander turns up and says to the parties, assume that Mr. Benyatov, whilst doing his job in Romania, is arrested and convicted following a trial in breach of his human rights, as a result of which, once he's made fairly redundant by Credit Suisse, he can't work again. Would Credit Suisse be liable for his career loss of earnings? To imply the indemnity, both parties acting reasonably have to say, of course. Of course, Credit Suisse will. That was so obvious that we didn't need to put it in the contract. Plainly doesn't satisfy that test. I hope I didn't fall into the schoolboy error, expressing the question in the wrong way. So for all of those reasons, in our submission, the judge was right to dismiss the indemnity in fact, and there was no error in him doing so. Well, that then deals with the indemnity claim, which takes us back, if back is the right way of putting it, to grounds 1, 2, 3 in relation to negligence. Now, before diving into these grounds, can I just make these general observations on the interrelation between grounds 1 to 3 that I think I touched on very briefly previously. The first point we make is self-evidently the appellant must succeed on ground 3, the limitation ground, because if he fails on that ground, his negligence claim fails. Secondly, assuming he succeeds on ground 3, must succeed in appealing the judge's finding that there was no duty of care owed. Grounds 1 and 2 state in terms that the judge was wrong to find there was no duty of care. But third, the appellant must also succeed in appealing the judge's finding that there was no breach of duty, which Lord Justice Singh reminded me is in section 9 of powers 246 to 288 of the judgment. In the grounds of appeal document, there's no express challenge to the judge's findings of no breach. Documents at C2, it's just put in terms of duty of care. We're not seeking to take a technical point that it's not open to the appellant to challenge the findings of breach because it's not in the grounds document. Particularly bearing in mind the appellant's skeleton argument when dealing with ground 2 at paragraph 34, where it said the court erred in failing to consider evidential matters in support of a finding of duty and breach. But it does remain important to recognise, we submit, that the appellant has to persuade the court the judge was wrong on duty under either ground 1 or 2, and on breach, which only arises under ground 2. So to summarise, without labouring the point, the appellant needs to succeed on ground 3 and either ground 1 or 2 on duty and ground 2 on breach.
You're speaking of duty. The alleged duty not to expose Mr. Benyatov to the risk of conviction in the performing of his duties. There is a duty of care, plainly, but the question of whether the facts of this case fall outside its scope.
Well, the judge found there was no duty of the sort contended for, either duty, as your lordship puts it, I think the wording in 24 is not to expose to conviction. And then we've got particular duties identified in support of that. And the judge obviously analysed that question in the light of all of the facts and matters relied on in support of that duty, and concluded that the facts were not made out, and so there was no duty.
Yes, I mean, it's a familiar problem, isn't it? But I think not a real problem. Do you say there is a duty of care owed by an employer to their employee? Answer, yes. But what is it? And then proceed to find out what its scope is. Or do you say, is there a duty of care on the employer to prevent loss of this particular kind? There's no real difference in substance between the two approaches.
Lord, you have to do the second with respect.
The first, yes, the first is now rather frowned on because
Yes.
we keep being told that you can't ask in general terms, is there duty? I think the reason why the first is still quite attractive in this field is we're very used to saying that in tort as well as in contract, the employer owes employee a duty of care, and dealing with questions of scope, as it were, as subsidiary to that. But I think that you're right, that is not the approach that's approved now.
And indeed, I think Khan and Meadows, which is a very recent Supreme Court decision, which was handed down just before our trial, so the judge considered it, and he cites from it, has an in-depth discussion of the relationship between existence of duty, scope of duty.
Yes, no, it's...
And it quotes from those well-known passages. I think there was certainly some in Caparo that says, in the same way you can't have negligence in the air, you can't have a duty in the air.
Absolutely.
You have to look at the loss. And that's why, maybe this is what Lord Justice Beam was driving at, you have to examine this duty of care in terms of the type of loss that it said there was a duty to prevent. It's financial loss resulting from exposure to conviction. There might well be a duty of care to protect the employee from physical injury in general terms, but that isn't the duty that's here engaged. What's said is there's the duty to protect against financial loss resulting from exposure.
At the risk of getting ahead of ourselves, though, just to flag it up, that is quite clearly how it's pleaded. Another way it could have been pleaded, which would have might have had less difficulties, would be to say there is a duty to protect against exposing the employee to the risk of bad faith criminal prosecution or involvement in bad faith litigation in a third country. which wouldn't tie you to any particular kind of loss, but might mean that if, for example, you were imprisoned in that place and suffered economic loss, you wouldn't just get damages for the loss of liberty, you would also get damages for the loss consequent, the loss of earnings or financial loss consequent on that loss of liberty, just as you would in a personal injury case. But this is pleaded as pure economic loss, partly, I suspect, because of the limitation difficulties that are got into if it's pleaded as a wider kind of duty.
Indeed, one can see in the APOC there's a reference to the deprivation of liberty, and it's expressly noted in the APOC that no claim was made in respect of that. One imagines that the limitation point was in mind. Lord, I'm not...
Yeah, I'm sorry, this is self-indulgent of me. I'm really just thinking aloud.
Lord, again, as
the
courts have said, one can't say, well, here's a breach of duty of care, now let's consider what loss follows from it, because the two are so intertwined. And one can't say there's a breach of duty to prevent physical injury. Well, now let's provide recovery for economic loss, unless it's directly consequent on the physical injury.
Yes,
right. So they really have to be packaged together, if I can put it that way. And this is a loss claim.
It doesn't really matter, but I prefer to use the word harm, which I suppose is the nearest Anglo-Saxon equivalent of damnum, because loss tends to mean financial loss. Theoretically, it doesn't have to.
Yes, but we say this
is... What kind of harm is what I would rather ask in this.
Yes, I follow. And the type of harm here is financial loss. But, my Lord, of course, the court is dealing, firstly, with the claim that is pleaded, not some other claim that might have been or could have been pleaded. That's what the court has to address. And secondly, this court, I don't need to say this, I know, has to address the grounds of appeal, not some other grounds or criticism that might have been made.
Yeah, right.
So, can I then turn to ground one, which is, it said that Judge erred in law in determining whether there was a duty of care in tort. And there seem to be 2 points made under ground one. Briefly put, they are 1, the assumption of responsibility ground, and 2, the incremental approach stroke rehab ground. So the appellant says, Judge applied the wrong test, he looked at reasonable foreseeability, assumption of responsibility is the test for determining whether there's a duty of care. And then he says, linked to that, but perhaps separate from it, the judge should have approached the incremental test through the lens of assumption of responsibility and decided that Rehan was an analogous authority that justified an incremental extension on the existing law. That's how it's put. Now, our response is set out in paras 19 to 41 of our skeleton, and it's fourfold. Can I just state what the arguments are? 1.
Sorry, just to say my noting.
Yeah.
The fourfold analysis you're about to give us, it does actually directly appear.
It does, my Lord.
Well, then I won't
19 to 41. I think I'm taking points 3 and 4 in a different, I'm reversing the order, but one can see above para 20 of our skeleton is point 1.
Got it.
We say it's a new point and it shouldn't be permitted now. Second response is, well, assumption of responsibility is not the test for this case anyway. And that's our second point above our para 26. It's the heading, not the proper test. Our third point, which I think logically is next, is the heading above para 38. It's our fourth point in the skeleton. Well, if assumption of responsibility can be taken now and it is the proper test, it's not satisfied in this case. And our fourth argument, which is number 3 above para 31 in the skeleton, is the judge's application of the incremental approach wasn't wrong, and he wasn't wrong on rehab. So that's the structure of our response. Now, if I can take those in turn, firstly, we say it's a new point that the appellant didn't argue below and shouldn't be permitted to raise it now. There are 3 authorities we cite in our skeleton, and there's a 4th recent one that I want to refer briefly to. The court, I'm sure, will be at least broadly familiar with these authorities. They are quite strong authorities, restrictive as to when a party can raise a new point on appeal that was not argued below. Can I just highlight the passages in the authorities? Jones against MBNA is at A2, tab 34.
Very familiar to employment lawyers. It's the case I'm thinking of.
Yes.
Surprised it. I thought it was reported somewhere.
Oh, well, we'll check, my lord. I couldn't find it in the...
Maybe it isn't. Yep.
And so, court might be familiar with it. Employee unsuccessfully argued that the bank had breached his duty of trust and confidence by acting in bad faith in dismissing him. On appeal, he sought to argue breach of the same duty of trust and confidence in other respects, and that was disallowed. And there are 2 key passages. First, at page 762 of the bundle, para 38, which is in Lord Justice Peter Gibson's speech. Could I just invite the court to read that? And then para 52, page 766, which is Lord Justice May's speech, judgment. I invite the court please to read that.
Sorry, I'm just behind. It won't take a moment to catch up. Yes.
And Lady Justice Hale agreed with both. That the second authority is Crane v. Sky, which is in A3 at tab 43. This was a case where an agent had brought a claim pursuant to the commercial agents regulations, which was dismissed. And on appeal, he sought to argue a new point, that he was within the mischief which the EU directive and the regulations sought to address, even if he wasn't an agent in English law. So that was the new point he sought to raise. And the relevant considerations, whether he should be permitted to do so, starts in Lady Justice Arden's judgment of paragraph 18. She cites from Jones, which we've just looked at, but if I could just invite the court to read para 18 until the Jones citation.
Yes, although it's focused here on amendment, I mean, the point can arise if the point's taken for the first straight away in the appellant's notice. So it sense the amendment is a distraction or perhaps an extra problem.
Yes.
Yeah.
At para 19, she refers to another older case, the Tasmania, but the extract from Lord Herschel's judgment again is quite relevant. She cites then at 20 from before Justice Peter Gibson in Jones that we've seen, but at 21 over the page.
Well, in fact, she cites a larger passage than the one we've seen.
She does. Well, she cites 39 as well.
Doesn't matter. Yep.
But at para 21, she comments on that and makes some interesting observations towards the end of the paragraph. Particularly the last 5 lines.
There's a slight tension, perhaps I should wait till we've gone to the end of this, between the very familiar and obvious point that the party against whom the new point is taken may be prejudiced if they would have conducted themselves differently in any way first time round. And a hint we get, certainly in Jones and some other cases, but that's only a factor. There may be cases where you just don't allow it in, even if that degree of prejudice can't be shown, that kind of prejudice can't be shown.
Yes.
On the basis that you're entitled to expect the whole thing to be done at the trial. My experience, courts are less sympathetic to that approach, very sympathetic in the case where it would have been argued differently below. If it's a pure point of law, we tend to let it in.
But I think we see hints of the former approach in these authorities, particularly in Jones, on the basis that party can come to trial expecting to know the case that they got to go to trial, they meet it, and that's it.
It's unfair to them, even if there's no prejudice, to be met with a new case on appeal. But I do see that point.
Yeah. As well as
just suggesting to you that I suspect one would find in practice that courts are a good deal more willing to allow amendment and to find that an unpersuasive argument.
There's interest of the efficient administration of justice as well. And I think one sees echoes of that in Lord Justice Lewison's judgments on appeals against facts.
Yes.
So it's not an efficient use of the court's resources.
Yes.
No, but isn't it all reasonably summarised in Singh and Das, which is the next one you're going to?
It is.
Cautious about a new point to be raised on appeal. Generally not permitted if it would need new evidence or the case would have been run below differently. Even if it's a pure point of law, the appellate court will only allow it to be raised if the other parties had adequate time to deal with it, hasn't acted to its detriment, and can be protected in costs. That's my experience after a few years in this court.
My Lord, your Lordship, as always, is a step ahead of me, and that's where I was going to.
Shows I should have contained myself until we got to that Singh and Das. Yeah.
But, I mean, Singh and Das is a pithy, succinct summary of what's discussed at greater length in the other cases. There's a more recent one, which is Johnson and Brent, which is not referred to in our skeleton because I think it wasn't reported then, which is A5 at 72. Sorry, it might have been reported just. Well, it wasn't reported, but the transcript was available. We hadn't picked it up. And Lord Justice Lewison may be, again, that's interesting because of his particular views on appeals against facts and efficient use of court resources, gives the leading judgment. To para 37, page 2037 of the bundle. First, he makes the obvious point at 37 that one can still take his objection even though PTA has been given. He then quotes from Singh and Das. And I'm not sure there's anything in 39 to pause over. 40 is quite interesting. He quotes from Prudential Assurance in HMRC, the judgment in which he sat with Mr. Clark and Sales, or justices. And there are some interesting observations set out there, and in para 41, which are relevant, we submit, to this point.
I do understand all of this, of course, but it might be said that a court, particularly an appellate court which issues decisions which are then binding, generally speaking, should get the law right. So if it is a pure point of law,
Yes.
like my lords, my experience has been that as long as there isn't prejudice and as long as there isn't unfairness, so if there's been adequate notice to the other side, well, we do try to get the law right.
Of course, my lord, I do understand the force of that. If it's a pure point of law, we do say here that the trial might well have been.
Yeah,
I'll come on.
that I understand.
But one notes at the end of para 41 as well, it said it will require a cogent explanation of the omission to take the point below. Right at the end of para 41, quoting from the Prudential judgment. That's an important consideration as well.
That does slightly not accord with my experience.
And
We all know that cases can look a bit different on appeal for a variety of reasons, especially we do our best. Counsel do their best to see every point, but the experience of seeing how it's put in the judgment and so on means that a different way of, and by the highest, a different way of putting it appeals to them by the very highest standards. You can say,
yes.
well, it was available to you then, it would available to you then, but that's a little bit tough.
Well, I understand that. It's partly why, in opening, I took you through those preliminary stages. So much time and attention was devoted to the law at the strikeout hearing. What was the basis for the duty of care? It's a bit surprising to see this argument introduced now. Could the court also just note para 47 in Johnson, which is sidelined, which is just part of the discussion? So, Lords, those are the authorities. Can I turn to the reasons why we say this point shouldn't be allowed now? And the first is that the appellant withdrew a case of assumption of responsibility below. We deal with this in para 22 of our skeleton, but could I just then take the court to a few documents to seek to make good this point, for which we'll need the supplementary bundle to hand, starting at tab 11. And page 53 in tab 11. Is the original particulars of claim, the pleading on duty of care and tort, and I invite the court particularly to note the first sentence of para 25, which, as we'll see in due course, was struck out. And then the second sentence is the duty of care not to expose. So this is how the case was originally pleaded. The respondent served an RFI, and the response of the appellant is at tab 13, page 70. And one can see from that page there's a request of that first sentence of para 25 for particulars of the facts alleged to give rise to the duty. And the reply was, by sending Mr. Benyatov to locations where he risked personal economic loss, there was an assumption of responsibility by the defendant to protect him from losses incurred. So there we see assumption of responsibility. And the one factor of sending to locations where he risked economic loss. Now,
I'm going mad. Which line is the phrase? There's assumption of
so
responsibility.
well, we're on page 70, and it's in the box 14.1.
40 point. Ah, sorry,
so sorry.
I was looking 40 point. No, it's not your fault. It's mine. Anyway, I found it.
Does your lordship see it now?
Yeah.
Thank you. And 14.2 request is for particulars of the second sentence of the original 25 about the duty not to expose to criminal conviction. And the reply makes no reference to assumption of responsibility in 14.2. Now, in the strikeout judgment, the judge struck out the first sentence of para 25. The appellant, as the court knows, applied to amend the particulars of claim, and the judge made a suggestion that it would be helpful if matters which were then in the RRFI, the response to the RFI, were incorporated into the amended particulars of claim insofar as the appellant sought to rely on them, so that everything was in one document. And this went through the tortuous process that I've described with the 8 iterations and so on, with permission granted to amend by order of the 21st of December, which is found at tab 18 of the supplementary bundle. So this is the order on the amendment application. And at paragraph 3 of the order, on page 160, the judge ordered the claimant may no longer rely on his response, dated 21st of May, to the RFI, save insofar as the RFI has been incorporated in the APOC. And as the court will imagine, these were all matters discussed at great length between the parties in correspondence and with the judge at hearings. And the appellant chose not to incorporate into the APOC what had been said about assumption of responsibility in the RRFI. So we proceeded on the basis that what had been part of the appellant's case was no longer part of the appellant's case, that there was no pleaded case of assumption of responsibility. That was influenced inevitably our approach to witness evidence, as well as seeking any further RFI.
Mr. Goulden, can we just look at page 70 of the supplementary bundle, the response to the request for further information? We've been looking at 14.1, which said by sending Mr. Benyatov to locations where he risked personal economic loss, there was an assumption of responsibility. Then there's 14.2, by sending him to emerging markets such as Romania, which were high risk, and so on. And 14.2 is incorporated, isn't it, into amended.
Yes, it forms part, I think, of the APOC 25 facts and matters.
Well, speaking for myself, looking at those two things in reverse order, seems to me that 14.1 is simply putting a different legal label on the much more detailed allegation in 14.2, which is absolutely at the centre of what the judge had to consider and on which he found in your client's favour.
Yes, Malord will be aware that assumption of responsibility is a very significant legal label, because there's a whole area of law around what assumption of responsibility means. And I'll go to a couple of the authorities, if I may, in a moment, because a learned friend has referred to them, and it's important to see what it would have meant if assumption of responsibility was engaged at the trial. Because the courts have made clear that, well, in order for there to be an assumption of responsibility, there needs to be focus on at least three matters. What were the exchanges passing between the parties to give rise to the assumption? Was there reasonable reliance by one party on the assumption by the other? And did the allegedly assuming party reasonably foresee that the other party would rely on them? So that would focus the mind very much on those matters that would have to then be explored if assumption of responsibility was claimed. So, of course, it might be said, well, these are factual matters which we rely on to establish the duty of care, but not using an assumption of responsibility basis for the duty of care, which would have meant one thing to lawyers. This is a document drafted by lawyers. That is taken out of the case. So we say that is significant. So, Lord, that's the first reason why we say this isn't simply a new point that sought to be taken now, but it was a point that was taken and then withdrawn. But secondly, the appellant invited the judge at trial to approach the duty of care on the basis of caparo and dictum, not assumption of responsibility. And if we've still got the supplementary bundle to hand, we can see at tab 34 an extract from the claimant's opening skeleton argument at trial. And at page 288, within tab 34, is the heading Breach of Duty of Care in Tort, legal criteria for establishing a duty of care, and there's reference to Lord Bridge. In Caparo, he set out the well-known three-limb test for establishing tortious duty: foreseeability, proximity, and fair, just, and reasonable. Para 100 says it's been cited on numerous subsequent occasions, and at 101 it develops that point and refers to Robinson. So that's how the case was put in opening, and in closing, similarly, at tab 46 in the same bundle, the claimant's written closing, and at page 352, para 197, the parties agree that in ascertaining the existence of a duty of care...
Sorry, I've just dropped behind. Which
sorry,
tab? No, it's my fault. Which tab?
46.
Yep, thank you.
This is the claimant's written closing, page 352.
Yep. And there.
And the parties agree, it said, the court should have regard to the factors in Caparo, and then they're listed. There's a footnote to our opening submissions as well as the claimant's opening submissions. For completeness, I'm not going to take the court to it unless asked to do so. Our opening submissions are found at tab 35, pages 292 to 297 of the bundle, and our closing at tab 47, page 356. So what emerges is, at no time did the appellant advance an argument at trial based on assumption of responsibility as the legal test. On the contrary, invited the judge to take a Caparo test. Neither party addressed the court on assumption of responsibility or authorities, and we submit the judge can't therefore be criticised for adopting the approach that the parties invited him to adopt and not adopting an approach that neither party mentioned. That's not an error of law. We're in an adversarial system, and the parties put cases they want to put and the court adjudicates. That was our second reason. Thirdly, we say if this case had been run below, it would or might have resulted in new evidence or in the trial being conducted differently. I mentioned a moment ago the three elements of assumption of responsibility that are recognised in the authorities. In fact, there's a very helpful summary of them in the RBS case, which we looked at briefly yesterday when I handed up the law report this morning. It's B5, tab 73. Paras 63 to 65. Lords Hamlin and Burrows at 63, quote from Lord Stain in Williams and Natural Life. The objective nature of the test means it will generally be important to focus on exchanges which cross the line between the defendant and the claimant. And then there's a passage from that judgment.
Sorry, I've just got lost.
So,
Where's
Paras
the bit
63.
about, 63, yes. So just seeing the whole sideline passage is quite helpful.
Yes.
It starts by referring to the academic criticisms.
Yep.
Then it refers to N and Poole, which I don't think we've got.
The court hasn't. That was a childcare case, so it was services being provided by a local authority. If helpful, we can provide it, but it's not in the document.
No, don't worry. Then the objectivity point, yes, right. Then 63 is what you were looking at. Yep.
So important to focus on exchanges which cross the line between the parties. And quote from Lord Stain, primary focus must be on things said or done by the defendant on his behalf in dealing with the plaintiff. Reference to exchanges. And at 64, the court there identifies those three factors which are relevant in assumption cases. At 65 notes, in the present case, no express assertion of assumption of responsibility is made in the amended particulars, and none of the relevant factors are alleged to be present in the case. And at 67 it said, by letter G, the fund has produced no evidence of reliance or indeed of anyone within the fund giving any thought to the possibility of the bank owing any responsibility, nor is it alleged the bank knew or ought to have known of relevant reliance. All the circumstances all concludes the fund has pleaded no factual case on which the duty of care based on assumption of responsibility could be established. So if assumption of responsibility was taken, we would have had to have carefully examined, well, what is it said were the exchanges passing between the respondent and the appellant that are relied on as giving rise to the assumption of responsibility. What evidence might we need to call in relation to those exchanges or things said or done by the respondent said to give rise to the assumption? What evidence might we need to call going to whether there was reliance and whether anybody at the bank foresaw or ought to have foreseen that Mr. Benyatov would be relying on the bank taking this responsibility? These were not matters that had to be focused on in that way in preparation for trial and were not the subject of evidence or cross-examination at trial. Of course, one can say, well, we looked at, the whole picture at trial, but there wasn't the necessary forensic focus that would have had to have taken place if we were facing a case of assumption of responsibility. Well, I'll move on, if I may. Those are the reasons why we say this point shouldn't be allowed to be taken now. My second point is, even if it is allowed to be taken, assumption of responsibility is not the proper test. The way in which it's put for the appellant is in paragraph 28 of my learned friend's skeleton, where he says the Supreme Court has repeatedly emphasised that the ordinary basis for the establishment of a duty of care in negligence is assumption of responsibility. And we say that's wrong.
Raise my eyebrows a little.
That's simply wrong with respect. He refers to two authorities, the Playboy Club and a quote from Lord Sumption in that case. I'm in para 28 of his skeleton. And Enram and Steel, or Northern Rock, as I'll call it, a quote from Lord Wilson in that case. Chronologically, the first of those two cases is the Northern Rock and Steel case, which is in A4 at tab 55. The short point about both of these cases is they're negligent misrep cases, negligent misstatement cases. So Enram and Steel, A4 at tab 55. Sure, it won't be disputed. This is a negligent misstatement case. This was a lender who sued a borrower's solicitor in negligence for an incorrect email about repayment of a loan. And one can simply see in the head note, letter E, that the claim is for damages as a result of the negligent misrepresentation. And my learned friend in his skeleton relies on the dictum of Lord Wilson in paragraph 24.
Sorry, which paragraph?
So in para 24 of the Northern Rock judgment.
Yep.
And what is quoted by my learned friend in his skeleton is the words right at the end of this paragraph in the last sentence, starting, although it may require cautious incremental development. That's the quote in his skeleton. And he relies on the words, this concept remains the foundation of the liability. But one has to read the rest of this paragraph, which is a discussion about the tort for negligent misrepresentation. Yeah. Because it's a discussion of Spring, Williams, and so on.
Well, Hedley Burn is really the origin of this, isn't it?
Yes.
Because the whole point was that, as the Lord said, we know there isn't a contractual relationship here, but it's very close to it. It's akin to it because the representor has assumed the responsibility.
Yes. And the point I draw attention to is that in negligent misstatement or misrepresentation cases, assumption of responsibility often is. Seems the test or applied or seen as particularly relevant. But what the appellant is seeking to do in paragraph 28 of Malone Friend's skeleton is take two quotes from negligent misstatement cases and say, the Supreme Court is saying that assumption of responsibility is the test for generally establishing a duty of care in negligence. So one sees in this para 24 from Lord Wilson, by letter E, he is specifically referring to Williams and the tort for negligent misrepresentation. The Playboy Club case, which is the second on which Malone Friend relies, was decided 5 months later than Northern Rock. It's at tab 57. And Malone Friend relies on a dictum of Lord Sumption at paragraph 7. And what is quoted in my learned friend's skeleton is at letter C of para 7, Lord Sumption's judgment, the defendant's voluntary assumption of responsibility remains the foundation of this area of law. That begs the question, what is this area of law?
So sorry, again, I was just...
I'm sorry, my lord.
No, it's my fault entirely. Quick. It's tab 57. Yep.
And it's paragraph 7, which is page 1379. this again is a reference by a bank to a casino. And at letter C in the para 7, this is quoted in Malone and Friends skeleton, where Lord Sumption says, the defendant's voluntary assumption of responsibility remains the foundation of this area of law. But that begs the question, well, what area of law is he referring to? The area of law is negligent misstatement, which we can see because, picking up my Lord Justice Singh's point, paragraph 6 on the previous page starts with a discussion of Headley Burn.
Yes, I mean, it's fair to say that he says at the beginning of para 7 that the principle has undergone considerable development, for example, to cover omissions and the negligent performance of services.
Yeah. Yes, I accept that, of course, and Henderson and Merritt would be an example of the negligent performance of services, but it's still the negligent either misstatement or provision of services from one party to another, particularly if there is no contract and where there's pure economic loss, where assumption of responsibility is relevant. That's recognised in the authorities.
But he also says omissions.
Yeah.
One can readily see, at least at the level of principle, that while the law might not generally impose an obligation on a person to act, in other words, it doesn't generally impose an obligation in respect of omissions, there can be circumstances where, because there has been an assumption of responsibility towards a person,
yes,
well, there could be. Isn't the present case effectively an allegation that there's a negligent omission here?
It is, my lord.
So why isn't the assumption of responsibility test an act test?
Well,
in this case?
Well, because it's particularly relevant where there is a provision of a service from one party to another. So let's take an example of an omission. A solicitor is engaged to draw up a will, fails to draw it up properly. Say that's an omission. They're providing a service to another party, and they might be liable in those circumstances to a beneficiary that doesn't inherit as a result of their negligent omission, causing financial loss. But in this case, whilst we have the elements, all of which are unusual in duty of care cases, of omission, financial loss and injury caused by a third party, we have a contractual relationship in existence. And assumption of responsibility in this sort of situation, we say, is not stipulated or prescribed by the Supreme Court as the test that has to be adopted. It is much more common in the negligent misstatement stroke provision of services cases.
Sorry,
Mark.
If you'd reached a natural. Now, the bench always likes best the cases it's found for itself, so you must aim off for that. But I think I mentioned yesterday to Mr. Chume the case of, perhaps it's even the day before, Barclays Bank and Customs Excise Commissioners and the speech of Lord Roger. And at paras 450 onwards, he looks at Henderson, he looks particularly at Headley Burn and Henderson and Merritt. And then he says there are cases which don't yield to analysis in terms of a voluntary assumption of responsibility, but where liability has been held to exist. I see no reason to treat these cases as exceptions to some overarching rule that there must be a voluntary assumption of responsibility before the law recognises duty of care. Such a rule would inevitably lead to the concept of voluntary assumption of responsibility being stretched beyond its natural limits, which would in the long run undermine the value of the concepts or criteria of liability in the many cases where it is an appropriate guide. I think that is the same. And then he quotes from Henderson and Merritt, where Lord Gough himself recognised, although it may be decisive in many situations, the presence or absence of a voluntary assumption of responsibility does not necessarily provide the answer in all cases.
Yeah,
that's very much what you're saying.
It is, my lord, and I'm grateful for that. I know I did look at that Barclays case a long time ago. And
It could reasonably be said, well, that was 15 years ago.
yeah, but one.
But I never see anyone disagreeing with Lord Roger.
No, I don't think so. And in fact, what I was going to go on to say was, in the Supreme Court in 2018, there were at least 4 duty of care cases in that year. And in 2 of them, assumption of responsibility is not considered as the basis of the duty of care. In 2 that we've seen, it was considered, which were negligent misstatement cases. And there's clearly no basis for suggesting there's
What's the other 2?
I was going to go to them very briefly, if I may. Taking them in chronological order, I'll mention the names. It's Robinson and then James Bowen are the other 2 cases. Robinson and Northern Rock were both handed down in February of 2018. James Bowen and the Playboy Club were handed down on successive days in July in 2018. Baroness Hale presided in all 4 cases. Lord Reed sat in 3 of them, excluding James Bowen. Lord Mance sat in 3, excluding Northern Rock. And so one wouldn't expect to see that there's any inconsistency of approach being adopted. Robinson is arguably the leading case on how to approach novel duties of care. And I don't think we've looked at it this week. Could I just invite the court to take up A4 and go to tab 54? This was the police officers arresting a suspected drug dealer in a busy shopping place and an elderly woman being injured in the process. The question was, did the police owe her a duty of care? The answer ultimately was yes, but that's already been established in the authority, so this is not a novel case. And it's Lord Reed's judgment really beginning between paras 21 and 29, which now tells us how to approach novel duties of care. And it's an interesting little historical journey through the case law, starting at para 21 by heading Caparo as a reference to Michael, Chief Constable, and then 22, Anne's and what went wrong with Anne's and the retreat from Anne's. At para 24, reference to Caparo and Lord Bridges' speech. And we have a summary paragraph at 27, normally only in novel type of case where established principles don't provide the answer. The courts need to go beyond those principles. Characteristic approach to the common law is to develop incrementally and by analogy with established authority. So as to maintain the coherence of the law and avoid the inappropriate distinctions. And para 29 again sort of restates that in slightly different words. So that's the general approach to be taken in novel duty of care cases in Robinson. Case next in time, before we leave that, at para 83 in Robinson is a relevant paragraph from Lord Mance's speech. And he says, as Lord Reed demonstrates, it's unnecessary in every claim of negligence to resort to the 3-stage analysis in Caparo, and where there are well-established categories, and so on. Towards the end of that paragraph, he refers to assumption of responsibility, but says in the last sentence, outside any established category, the law will proceed incrementally and all 3 stages of the Caparo analysis will be material. So if you're in a novel case, he says proximity, reasonable foreseeability, and fair, just, and reasonable will all be material. And Lord Hughes...
Forgive me, before we leave Lord Mance, I have to say that that chimes with a thought I had, which may be the wrong way of looking at it, which is why I'd like your help. I have been wondering whether the overall framework of principle is as set out in Caparo and Robinson, but in asking in a novel context whether the Caparo criteria have been met, I wonder whether the concept of assumption of responsibility helps us to answer that question. Lord Mance appears to be approaching it in that way in economic loss cases.
Yes, in a Headley Byrne type case.
Yes.
Not sure that it's all economic loss cases.
No.
But in a Headley Byrne type case, then yes.
I see that. And it may be because they didn't. Obviously, no court has everything in mind, and there's no reason why they should. But one is aware that in the decades since Headley Byrne, there have been contexts like, for example, local authorities having to look after children.
Yeah.
They may be negligent omission cases sometimes, because it may be that harm is caused by a third party. There are the police cases about failure to protect somebody's life when you knew that there was a risk to that person's life, things of that sort.
Yes.
But I'm just wondering whether, analytically, whether the concept of assumption of responsibility isn't a substitute for the Caparo criteria, but it may help to answer the Caparo questions in certain contexts.
Lord, I respectfully agree. We're not suggesting here that assumption of responsibility could not have had a role. We're not saying if the judge had applied that approach, he would have been wrong to do so. But we are here responding to the suggestion in the appellant's argument that he had to apply assumption of responsibility, and we say that's wrong. There are many cases where the courts have discussed the different types of tests, and three are often referred to: the Caparo test, the incremental test, and the assumption of responsibility. And what's said in some cases, well, actually, you'll often get the same result, whichever test you apply. Sometimes it's quite useful to cross-check and ask the questions under the different rubrics. But we are saying there is no one test that has to apply. This is not a case where one should have said it has to be assumption of responsibility, particularly where it was not argued, but only Caparo was argued. I was going to just refer, if I may, to Lord Hughes's judgment, paras 99 to 100, and where he says at the bottom of page 1330, the last two lines in para 99 on that page, the general rule of law of tort is that the foreseeability of harm is a necessary but not a sufficient condition for liability. And that's rather important, because he recognises there that whatever test you apply, there has to be reasonable foreseeability of harm. And of course, it's that which Mr. Justice Freedman found was not satisfied in this case. The third of the four tests cases chronologically was the Northern Rock case, Enram v. Steele, and then the fourth in the Supreme Court in 2018 was James Bowen case. I know we looked at that briefly yesterday. Could I just invite the court to turn it up again? It's the same volume 4 at tab 56. This was the police officers arresting a suspect.
Yes.
And
so is Robinson, but it's a very different kind of case.
Yes. And it's treated as...
It's more the police... it's more about the handling of the litigation.
It is, yeah. And... but it's treated as an employment case, or quasi-employment case. And we see, particularly from para 14 onwards, there's a discussion by Lord Lloyd Jones' judgment about the duty of trust and confidence. And there's some interesting and relevant paragraphs. I'm not going to take too much time on it now, but para 17 and 18 in particular, where he refers to the deriving an obligation from the duty of trust and confidence for that case would be to move substantially beyond the specific derivative duties established to date. It refers to Malik, a para 20 to Crossley, which we looked at yesterday. And he repeats Lord Justice Dyson's comment in para 20 by letter E that it's not for the court to take a big leap to introduce a major extension of the law in this area. And what one sees in the James Bowen case was that the police officer's claim was based on both assumption of responsibility and caparo, or general duty of care. We see that from para 7.
Are you coming back to para 20? Is the last sentence?
Yeah.
Makes a clear distinction between how assumption of responsibility might arise.
Yes.
Anyway, sorry, you've taken us to para 7.
Para 7, the claim was brought in 3 ways. 1, a retainer. 2, assumption of a duty of care. And 3, a general duty of care in tort. So what the police officer said in that case, this is where they had received assurances from the legal team for the commissioner that the individual officer's interest would be looked after. And they said, oh, well, you've assumed a duty of care to us in the conduct of this litigation. The claim was struck out in its entirety at first instance. The Court of Appeal dismissed an appeal based on assumption of responsibility, but allowed the appeal based on general duty of care. And the Supreme Court struck out the claim in its entirety. So for present purposes, it's an example of a case where there was a pleaded claim based on assumption of responsibility that was dismissed as unarguable, notwithstanding that the Commissioner's lawyers had made express assurances to the officers that their interests would be looked after. But the Supreme Court proceeded to consider whether there was a duty of care that arose on the basis of general principles, not assumption of responsibility. So one can't say that assumption of responsibility is the test that has to be applied, because the Supreme Court here considered whether a duty of care arose without considering assumption of responsibility. And it's particularly interesting to look at paragraph 24 of Lord Lloyd Jones's judgment, where again he discusses Spring and then Hedley Burton. And he says, just below letter H, this case, I think he's referring to Spring, was essentially concerned with negligent misstatement. And it may be that assumption of responsibility is the better rationalisation of the recognition of a duty in these circumstances. And in fact, he quotes Northern Law. So he is suggesting that assumption might be more appropriate in a negligent misstatement case. And that's inconsistent with the appellant's submission that it really is the foundation for all duty of care cases. Nors, I fear I might have spent rather too long on the interesting authorities on assumption of responsibility, but it's, I hope, made good, or it's intended to make good, my submission that assumption of responsibility is not the test that has to be applied in all cases. And therefore the judge did not err by not applying that test here.
Now I see the time. Are you reasonably up with the clock? You've got to cover a little bit more on ground 1, or is it ground, the assumption of responsibility ground?
Yeah.
You've got to deal with ground 2.
Yes.
Fact, which we appreciate they dealt with it quite Chume, but you may nevertheless want to take more time, I don't know. And then limitation. So, but, and then you're going to leave enough time for Mr. Chume. So, you're comfortable with that?
Well, my lord, I'm going to impose a guillotine on myself, at least to give Mr. Chume some
Yes,
time to reply.
I think on a strict view, you needn't give him the full hour of your original agreement because he overran on his, but you must give him a substantial period of time.
Understood.
Good. Well then, we'll sit down at 2 o'clock.